we are about to officially begin with the program today, and I, on behalf of Delhi High Court Legal Services Committee, welcome you all here today. It is because of the active participation of you all that Dhclsc is able to successfully put its vision of upscaling the professional quotient of its empaneled advocates in action through such capacity building sessions like one today. I would request Mr. Arul Verma, Additional District and Session Judge and Learned Secretary Dhclsc, to kindly present a potted plant and a memento to Mr. N. Hariharan as a token of gratitude. Thank you, sir. An advocate's skill in argumentation is akin to a craftsman's mastery of his tools. It's the ability to shape, persuade, and illuminate the path towards rectitude, ensuring that justice prevails. This saying delivers the spirit of today's session. The resource person for today's session, Mr. N. Hariharan, Senior Advocate, is associated with Dhclsc since 2018 as an active member of its mentoring and monitoring committee. Sir is a first-generation lawyer with over 35 years of law practice extensively in criminal law. Sir has represented clients in crucial cases like Shivani Bhatnagar case, Dhclsc case, 2G spectrum allocation matter, to name a few. Sir even appeared as a special counsel for Salman Khan's prosecution in the Black Buck shooting case. As an advocate for civil liberties and individual rights, Mr. Hariharan represented clients in the Sura Hooch tragedy cases where over 200 people lost their lives due to consumption of spurious liquor. There is no iota of doubt that we are hearing from the best today. I would request, sir, to kindly address the gathering. Over to you, sir.
My friends, I really don't know what skills of arguing I have. You will determine that by the end of this session probably. That's all I can say. The topic is a little different. It basically relates to the skill of persuasion, as I could make out. The little that I could make out of this topic. Skill of arguing for the purposes of persuading the court. So this set me on a kind of quest. Where did this skill actually come from? Where did we actually develop these skills? What was the origin of all this? So on this quest that I undertook, I hit upon what is known as classical rhetoric. I don't know how many of you have heard of this. The Greeks, the ancient Greeks, they are supposed to have developed the skill of what is known as classical rhetoric. Though it is the pharaoh Huni, the pharaohs of Egypt, of which pharaoh Huni was the first man who probably instructed his son on the skill of persuasion. That is the first recorded evidence that we have of this, essentially related to public speaking. But when we talk about classical Greek philosophers, the man who developed this concept is a man whom most of you would have heard of. He is a man called Aristotle. Aristotle lived in very interesting times, and it is, a matter of interest that even in those ancient times of Greece, because he lived way back in 384 to 322 BC, and this rhetoric that I am talking of was developed by him as a skill of persuasion then in relation to an argument. So what did he say? He wrote a book called Rhetoric. It's a dense book. I of course would recommend that when you find time, translations are available from Latin and Greek, because first it was translated into Latin and then subsequently from Latin to English. So rhetoric, you will find, essentially is a very interesting book which relates essentially to the aspect of arguing any kind of matter before any place, to persuade a human being. What is it that is required in that skill? So what he does is that in rhetoric, he says that there are three elements to an argument. And the three elements to an argument, according to him, are: one, the argument itself; two, the speaker; and three, the most important component of the same, the listener of the argument. So essentially that argument is being addressed keeping the listener in mind. So what does he say? How to address this argument, how to make it in such a form that it captures the interest of the audience. Now for that, he uses again three situations. He says that there are three elements in relation to the addressing of an argument which will essentially contain the interest of the listener. It is essentially tailor-made for the listener as such. So the first element that he talks about is something called ethos. Ethos would mean what the listener perceives. What the listener perceives of the speaker. So that is the ethos. So what he says is that when the speaker creates an impact in the mind of the listener, and how does he create that impact? That impact, he says, is in creating a belief in the listener as such, that one, is a man of integrity. What he is speaking essentially brings out the truth of the proposition. So he induces that kind of belief while he is addressing the listener, and that is the ethos of the speaker. The second element, which is the most important element in an argument according to him, is something called logos. Logos, logos, which essentially derives the word logic is derived from there. So he says that the second element of the argument is the reasoning on which it is based. If it is based on sound reasoning, then the argument will have weight. And the third element is the pathos part of it, which means that part, pathos, again the word essentially has a connect to the word pathetic. It appeals to an emotion. So pathos is that which appeals to emotion. So essentially the argument will, if it contains these three elements to it, the ethos part, which is essentially addressing the listener, the logos part, which is the logic of the argument, and thirdly, the pathos part, which addresses to the emotion of the audience. Then the argument will essentially capture the audience's attention. Talking about Aristotle, so post rhetoric, this rhetoric started being used thereafter in his very times by a very interesting person by the name of Demosthenes. I don't know how many of you have heard of Demosthenes. Demosthenes was a speaker because in those Olympiads which they used to hold at that time in Greece, ancient Greece, there were Olympiads which were held in relation to public speaking as well. Apart from the games which you see, there were Olympic wreaths which were given even for public speaking. And one of the foremost speakers there happened to be a man called Demosthenes. The interesting part of Demosthenes was that he had a stammer in his life. He would stammer whenever he would speak. And it is said that he closeted himself at home, and after having closeted himself at home, he would practice before a mirror with pebbles in his mouth to overcome the stammer. And it is historically documented that not only did he overcome the stammer, he turned out to be one of the finest speakers and orators that Greece produced. Now, why did I refer to Demosthenes? Because Demosthenes was a man amongst the three principles that I just spoke of: ethos, pathos, and logos. He was a man who employed logos in his arguments, reasoning in his arguments. And the kind of reasoning that he employed, a little bit of history there will help us to understand the perspective in which I am trying to put this in place. The little bit of history that I am referring to is the times in which Demosthenes lived. You know, Greece at that point of time was a kind of conglomeration of republican states. And these republican states included states like Athens, Sparta, and many others. All of you have heard about Athens and Sparta. Sparta, they say, is the fount of democracy, where democracy actually originated from their systems. So living in those times, in the land of Macedonia, there arose a man who usurped the powers of the republic and declared himself as the king. And this man was a man called Philips. Philips of Macedonia, who happens to be the father of Alexander. So I am talking about one generation before Alexander. When he usurped the powers of the republic, Demosthenes, who was an Athenian, there was at that point of time a threat to Athens from Philips. Philips had gone around conquering other places. So when this was happening, Demosthenes addressed the people of Athens in relation to the value of democracy, and also he essentially tried to incite in them that emotion that they need to speak up. They should not sit and let things happen. They have to respond to the same. So in relation to that, he used a device which is called, within rhetoric, a device of confrontation. Now this is something which is a little useful, because these are also techniques today, when we will analyze a little later when we go ahead, how these techniques which I am talking of are employed by you lawyers every day. These are techniques which are honed by you over a period of time. The kind of reasoning which was used also, which I will deal with a little later when I talk about logos, logical reasoning. Because logical reasoning will contain two aspects to it. You reason in two ways. One, you reason by deduction. And two, you reason by induction. These are two different methods, inductive reasoning and deductive reasoning. Both these concepts have come from the element of rhetoric. And most of the growth of law today has happened by inductive reasoning. It is inductive reasoning where you use the element of analogy. You cite a case law, you cite a precedent when you are arguing a case, that it is similar to what you have at hand, and therefore the court should employ that particular precedent in your matter and deliver a judgment in your favor. What are you doing? You are essentially using inductive reasoning. So I will deal with inductive and deductive reasoning to a certain extent, because the time constraint will also prevent me from going into a very long lecture. I will try and somewhat squeeze it within the time frame that has been given to me. But before I do that, I would wish to read some portions of the kind of speech which Demosthenes gave at that point of time to show you the confrontational method that he used. I will quote from Demosthenes' speech for a minute in order to take you there. As I said, the background is when Philips of Macedonia is trying to overpower the other republican states, including Athens. So this is what Demosthenes says. When then, Athenians, when will you do your duty? What must happen first? When there is a need for it? What then should we consider what is now happening? For in my opinion, the greatest need is a sense of shame at the political situation. Or do you want, tell me, to go around, ask each other, is there any news? Could there be anything more newsworthy than a fellow from Macedonia defeating Hellenes, that is Athens, in war and regulating their affairs? Is Philips dead? No, he is not, but he is ill. What difference does it make to you? If anything happens to him, you will soon create another Philip, if this is how you attend to your business. Now, what is this method? when we look and analyze this method, what is being employed by Demosthenes, when he is speaking to the people of Athens, the method that he is employing is the method of confrontation. He is confronting them. He is not only confronting them, he is also essentially telling them to engender action. He is telling them not to be complacent in his own distinct way by confronting them. He also acknowledges in what I read just now that there is resistance to action. The people of Athens are essentially resisting that action, they are keeping quiet. He is giving a voice to that by addressing this, and by this confrontation that he is taking with the audience as such. And there is a response to it as well. He is responding to it by force. He is telling them to respond. The lines when he says, what difference does it make to you? If anything happens to him, you will soon create another Philip. If this is how you attend to your business. This is not only relevant in today's times, this is also a technique which as lawyers we employ, confrontation. When I say that as lawyers we employ this technique, how do we do it? We do it by anticipating the opponent's case, number one. In moments of argument in court, we also acknowledge that there is a situation there. And then, whatever doubts come into the mind of the judge because of this confrontation, what we do is that we address those uncertainties. If we are not going to address what is there in the mind of the judge and leave it at that and skip a little further, it will create a wrong impression. So the technique of Demosthenes of confronting the problem, addressing the problem, and then articulating a response to it is what you do in court in relation to your matters on a day-to-day basis. So therefore, this is the element which we have taken from rhetoric, and this was the contribution of Demosthenes apart from one more aspect, and that aspect was in a technique for what was at that point of time known as repetition, anaphora in Greek. What was the effect of repetition of words? Words used to be repeated to give effect. Now this repetitive part in terms of what Demosthenes used to do, we as lawyers employ it in the context of when we examine witnesses, say, in a trial. In a criminal trial, for instance, the prosecutor, supposing he wants to emphasize on a particular point, because what happens is that as I started the address, I said that the most important key in the said address is that of the listener's viewpoint. Everything is addressed keeping the listener in mind. So, when a matter is introduced in a trial in court, the emphasis of repetition essentially captures the interest of the listener, because the listener's interest in relation to the concerned problem is very ephemeral. It lasts for a very little point of time. So the questioning would be somewhat in the context of a witness examination. This is in relation to the chief. Tell us what time you returned home in relation to the said particular situation. The next question would be, when you returned home, did you see someone there? Did you see anyone or did you see someone? Then further, when you returned home at midnight and saw your mother, did you notice anything that was amiss? So again and again, the repetition is on the aspect of when did you return home. What the prosecutor wants to drive here is that the witness returned home. His presence he is trying to establish there by way of this line of questioning to the witness. So this methodology that he is employing is the methodology which is known as anaphora or the effect of repetition, which we employ, again taken from the rhetoric. The next figure which comes into my mind after the Greeks, who refined this, was one of the greatest orators of the world, who is considered to be the father of lawyering. The man was a man called Cicero. Cicero also had a very interesting life. Cicero lived in turbulent times. He lived during the times of Julius Caesar. All of you know that when Julius Caesar seized power, the Republic of Rome at that point of time also got destroyed, and it came into the hands of what was known as the triumvirate. The first triumvirate comprised of Julius Caesar and two others. Mark Antony was another one, and there was a third as well. Caesar, all of you know, did get assassinated and was assassinated by Brutus. Post the assassination, Cicero essentially became the spokesperson of the Senate, as the Parliament of Rome at that point of time was called. He became the spokesperson of Senate. He was a man who, after having become the spokesperson, he assailed Mark Antony, the part of the triumvirate, for being responsible for the state of affairs that Rome was witnessing. He stood for the rule of law to be upheld at that point of time, and that is why Cicero was remembered. The reason being that Cicero also lost his life for upholding the rule of law, because Mark Antony, when he came to power, he saw to it that Cicero was assassinated. But before all this happened, the speeches that Cicero delivered luckily has survived like the rhetoric, and interestingly, he also compiled these set of speeches by emulating what Demosthenes did when he did to Phillips by writing what is known as the Philippics. The Philippics of Cicero is also a point which I would in fact recommend to all of you, a book which all of you must read. I of course cannot dilate on all that Cicero did, but some aspects of Cicero which are employed today in terms of pursuing an argument in court. One of the most important things as far as Cicero was concerned was the doctrine of primacy and recency. This is a doctrine which each one of us employs. And what is the doctrine of primacy? The doctrine of primacy is very simple. This came from Cicero. The doctrine of primacy was that you remember best what you heard first. That is the doctrine of primacy. So when you open an argument in court, invariably, you put your best foot forward. So when you put your best foot forward, that is something which leaves a lasting impression on the judge. At the same time, because Cicero used to build his argument in such a way that it had the basics which was enumerated none less by Plato in what he wrote as the Republic, where he said that an argument should essentially be structured. It should have a beginning, it should have a middle, and it should have an end. So from the end, Cicero developed the second concept, and the second concept which also is employed is the concept of recency. So there were three aspects which Cicero gave us. One was the first concept of primacy. How you open an argument, what is the best foot that you put forward. How you open an argument would mean what is the best aspect that you have in your case, the strongest point in your case, you marshal it towards the beginning. And the middle, in between, is filled up thereafter with logic in support of the said argument. And third, what he developed was what is known as the doctrine of recency. Primacy and recency. Primacy and recency would mean that when you leave or conclude your argument, at the time of concluding your argument also, you leave the court with the best argument that you have, which leaves an impact. So this was the technique which was employed by Cicero in most of his arguments that he made. Interestingly, today's modern world, when we address arguments in court, we employ three things. We derive two from Cicero and one from Demosthenes. We employ primacy, doctrine of primacy. We also employ doctrine of frequency, repetition, to have impact. And we employ the third aspect of recency. So here we find from the rhetoric the contributions in relation to what various people did at various points of time has ultimately contributed to the kind of argument which we marshal in court. Now, having said this, I personally feel that there were, talking about the rhetoric and the kind of rhetoric that is employed in today's times for a purpose of clarity and for the purposes of persuasion, there would be 6 or 7 aspects which modern advocacy employs. And with those 6 or 7 aspects, I will leave you with that thought in relation to how to build an argument and how to sustain an argument. The first element is to identify a theme, what they call identification of a theme in an argument. A general theme in relation to a matter would have certain building blocks in it. And what is the building blocks as far as a lawyer is concerned? It is the evidence which is there in your matter. It could be legal authorities which you intend to cite, the precedents in relation to the same, the public policy in relation to the entire issues, and the essential facts which govern your matter. This would be the general theme of your case. You will use this general theme in the entire structure of the argument to ultimately reach your goal. So you need to first identify this theme. Once this theme is identified, on the basis of these building blocks, you will develop a coherent and organized argument to advance your cause. Then the second most important aspect is considering your audience, to whom it is being addressed to. Now this is a very important component because you generally address your arguments before. We don't have a jury system here. We have the judiciary here. So therefore, what may be clear and relevant to one judge may not be clear and relevant to another one. The same set of facts will produce a different kind of result. You all have seen it so many times happening in court. So what do? Study the judge. That is the most important thing. Try and understand what is his psychology. What is it that he thinks? What are his preferences? What are his inclinations? What are his beliefs? How do you get to that? Look into what he has delivered already. Read his previous judgments. Specifically, if you can find propositions which he has dealt with in relation to your matter, some similar matter like that, then you know how to handle him. You know that if I take a particular direction, this may not go well with him. So you need to change your track according to the kind of judge that you are going to argue your proposition before. So you need to study him. And studying him, there are many ways of studying him. One is not only through the judgments that he has passed, it is also consulting each other. Some of you must have had experiences before him. You can gather a lot of insight into the psychology of the judge by discussing amongst your own colleagues as well. So there are various ways of looking into the psychology of the judge. Why I say that this matters, small examples. personal experiences. I remember at one point of time when at that point of time there was the NSA which was being invoked. Advisory tribunals were constituted, and in those advisory tribunals at that point of time in our High Court itself, 3 judges would sit and then consider the representation of the person who was already incarcerated. There was preventive detention at that point of time. Most of you must have, who have done this side of the fence, would have seen. So we used to represent the councils as councils we used to represent the person there. So how does the predisposition of a judge work? At that point of time, Justice J.K. Mehra, as he was then, was one of the members of that board. I was representing a hardened client of mine, I won't say criminal. The case, most of the cases in relation to him related to extortion. And he used to operate in a place called Azadpur Sabzi Mandi here, in that area. So matter came up. So before even the entire thing could start, I decided to put in an introductory as far as his case was concerned, that there was no right of hearing given to him and he had a cause which was to be considered by them. The moment I started on that, J.K. Mehra stopped me. Justice Mehra stopped me. And you know what he asked me? Mr. Hariharan, have you ever faced an extortionist in your life? God forbid you haven't faced one. So this is what I met with at that point of time, which showed the predilection of the judge. That he probably had a previous experience somewhere. And at that moment itself I knew my client's representation is going to get dismissed. And it got dismissed. Ultimately we had to come on a writ. That's a different thing. But what I'm trying to give you is an example in terms of perceptions. Preconceived ideas which people have. Right? Those of you who practice on the criminal side, for instance, as a lawyer, we are predisposed in a particular fashion if we are on the defense, that we don't trust policemen. Am I right? Do we have that notion when we practice on the criminal side? So we work with that preconceived notion. Similarly, there are judges who have preconceived notions about them. One set of judges may think that, look, this man is performing his duty. He is there all through day and night. And here are these bunch of criminals who want me to deliver a judgment in their favor. They talk about liberty and all that is fine. Tomorrow, walking around on the street will be difficult for us. So there is that belief which that person is having. Now you have to battle against that belief. On the other hand, you will find prosecutors defending them tooth and nail. Everything that a policeman does is justified in the eyes of the prosecution. Again, pre-structured belief, because you have been in that line of work, there is a pre-structured belief that you have in your mind. So that is why when you are addressing an audience, what is the belief that is there in the mind of the audience is really very important. It helps you to understand and structure your argument accordingly. Take for example, you have gone to a doctor in a hospital. You meet a doctor and he has been negligent in some way, which resulted in privation of either your limb, he botched up an operation. You will have a particular predilection when you deal in relation to cases of medical negligence. Right? So it is that belief which matters. I can give you one by my example. I will not name the person because the cases are still going on. There in this city is a very famous orthopedic surgeon, probably the best. Interestingly, the matter in which I appear, before that, I had the occasion to go and get a consultation from him because I have a bad right knee. I had an accident way back in 1984 which gives me difficulty in walking. So I went up to him. He looked at me and said, "What is it that you want?" So I said, "I wish to run." He said, "Okay, you wish to run? Then in that case, I'll have to operate both your legs. My left leg is absolutely fine." So I looked at him and said, "Look, I didn't come with a scheme here, one and one free. No, I don't want that. I came for 1 foot, and you have given me a scheme of 2 foots." That ended there, and subsequently I get to know, when this particular case comes to me, that this doctor operated upon another doctor who came all the way from Australia, was negligent in terms of looking into her reports before operating. And that lady, post the operation the next day, because this was not checked, died due to the fact that there was a embolism which travelled from her foot to her heart. There were certain aspects in relation to that which are termed as the Dhclsc test. There is a triad which, if he had seen the pre-anesthetic tests which he ignored, would have shown him that it was not right to operate her. Anyway, the case is under progress. The issue is that now, if anyone asks me that should I go to that man to get my knee operated for a knee replacement, it is my predilection to say that, look, he is not the right man. Maybe he is very good, but this preconceived notion has now entered into my head. So experiences which are there in your lives as judges or as lawyers, they at a different level operate in your mind. So when you address an argument, you need to address those beliefs, those kind of predilections, those kind of beliefs which a person has, to structure your argument, to ameliorate that amount of damage which could be caused because of that kind of a preset mind. So that is why the second most important aspect in terms of modern term rhetoric being applied to the art of persuasion is to consider the audience. Now, having said that, the third, of course, all of you know, the most important thing to an argument is that it should have logic and reasoning. If that part is missing, then there is no argument at all. So it has to be based on logic. And that is where I am coming back to what I initially had made a reference to, and that was the two aspects of reasoning which we employ. One, deductive presentation, and the second is the inductive part. Now, what is the difference between these two? As far as a deductive presentation is concerned, this reasoning progresses from something general to something specific. This is the manner in which you deduce a particular aspect. It starts from a general theme and moves to a specific theme. Now, when I say that, those kind of arguments, when it comes in this form of deduction, invariably you will find that the logic that it has in relation to what it is deducing is normally a situation which cannot be combated. Now, for instance, I will give you an example from, say, mediation. Some of you are mediators here. I can find a few of my friends here. In mediation, imagine a situation where the mediator is pressing upon you to advise your client to pay the plaintiff. He is pressing upon you to pay the plaintiff. Now, when this happens, you essentially know that what is being urged is to make payment of a debt which is barred by limitation. You know it from the facts. So you press upon this by saying that, you see, the limitation prescribed in relation to paying this debt is 3 years. And this case has been filed 5 years down the line. After the breach has happened. When you say that, automatically comes the deduction that a time-barred debt need not be honored. It is as the suit as such has been brought for nuisance and needs to be dismissed. This is something which is known as deductive reasoning. This is going by deductive reasoning. So it is moving from a general proposition to a specific proposition. The general proposition being that a time-barred debt need not be honored. The specific proposition to which it is moving is, in your case, this claim has come after a period of 5 years. So therefore need not be honored. This is the deductive part of it. Now interestingly, my lord, what I come to is the aspect of inductive reasoning. This is the second part. This one moved from a general aspect to a specific aspect. That will move the other way around. That will move from specifics to a general conclusion. Now, how can this be addressed? I will give a very simple example to understand this. Because inductive reasoning has many aspects to it. But this is the simplest part which I could think of. There's this Costa coffee which has been opened here. Last time when I came, they said that this Costa coffee is being opened. Starbucks or whatever. Starbucks, okay. So, the first element is that, I go and have something at Starbucks and I find it is rotten. I didn't like it. Second time, after a week, I again go there. This time with my friend Dhclsc. He says that, come, I'll give you a treat there. I go there. This time also I find that it is not up to the mark. Then there is a third occasion when Vivek takes me. The third occasion also I don't like it. Now on the fourth occasion somebody says that will you go there? I said no. On 3 occasions I have gone there and the food was rotten. So 3 specific instances. The induction being, the inductive logic being, that food there is generally bad. So that is the inductive way of reasoning, which is moving from a specific circumstance to a general circumstance. Deductive reasoning moving from a general circumstance to a specific one. Now inductive reasoning has also another very interesting element to it which we employ, and that is that inductive reasoning happens by analogy. Comparison. This is where we use the same when we talk in terms of citing a citation. We say that there is an analogy to it. Our facts are parameteria to the ones which I am citing. Similar situation of facts, similar set of facts, a particular judgment is being delivered. So therefore, that specific facts which brought about that particular judgment should be applicable to what I am arguing as well. That is again inductive reasoning. So induction is a method by which generally the growth of law has happened. By use of precedent and analogy, and then the use of inductive reasoning there onto it has brought us to that situation. So therefore, the second most important aspect in relation to containing the attention of a listener, I again go back to rhetoric, is the element of logic, reasoning. So the reasoning is strong. That is one of the elements of a persuasive argument. Whether it is by way of deduction or it is by way of induction, the reasoning should be sound. There are situations where deductive reasoning may fail. There are situations where inductive reasoning may fail. Now let us go back to that example which I gave in relation to mediation. Right? Where we started with this premise that there is a limitation period of 3 years. and the suit was brought, or it came up for mediation, where the claim was brought after a period of 4 to 5 years. So in relation to that deductive reasoning, the first major premise which I used was that as far as a debt is concerned, a debt can be claimed within a period of 3 years. I used that method to reduce to the fact that this has come after 5 years, so therefore this needs to be dismissed as such. But consider a situation that there is law in a particular jurisdiction which says that that limitation will start from the point of discovery. Your limitation will run when you get to know, when you get knowledge of the fact that this is the situation. When you get knowledge of the fact that from this point of time, limitation will run. If that be the case, then what I reasoned earlier can be combated by the other side by saying that all that is fine. But I discovered this 4 years or 5 years thereafter. So my limitation will run from that point of time. That deductive reasoning will fail. Because the first fundamental premise on which it was based was not correct. So therefore, when we employ these techniques in court, we need to be very careful as to what we are employing is actually correct or not. Now, having said this, I come to the next aspect, and that is appeal to emotion, pathos. Emotion does help, and it helps in many ways. When logic combines with the emotional part, it makes it a very powerful argument. Especially in criminal law, with which I deal more or less in and out. The pathos part of it is as important as the logic part of it. When you appeal to the judge saying that, look, you are asking for a lesser sentence, you are appealing to the emotion of a judge. When you are talking about the conditions which exist for your client, how he is in a state of penury, how that crime occurred in a particular social setup, how there were constraints in relation to him, how you seek the award of probation, for instance, that's a first time offense. You are all appealing to the emotion of the judge. How well you are able to create that impression based on the facts that you have collated makes all the difference. So logic is one part, the emotional element is the other part. At times it can be counterproductive also. If you rely too much on emotion, it may prove to be counterproductive. At times it is useful to play down the emotion as well. So these are all techniques which you people employ. This is nothing new which I am trying to tell any one of you. In fact, I personally learn all this when I see all of you in action. The third, of course, having talked about emotion, is how you structure your presentation when you argue. As I said, from Plato, we derive this that there has to be a beginning, a middle, and to an end. And here come those elements of Cicero as well, to take advantage of the doctrine of primacy. Also, wherever possible, take advantage of the doctrine of recency as well when you conclude the argument. And then, as I had explained, in terms of frequency, depending on a criminal trial, for instance, the element of frequency is very effectively used when we cross-examine witnesses. That, of course, is a different story. Now, in today's times, of course, I see, because I belong to an era where visual presentations were not our cup of tea. But yes, in one of the lectures that I gave in the Indian Institute of Law, there I found Justice Bambani using visuals to a great effect. PowerPoint presentations being used to emphasize points. Because they say that a picture essentially is worth, visually, when you show a picture, it is worth more than 1,000 words being spoken. Because what do we do when you employ words? We are also trying to create an imagery. The picture is the imagery itself. So it speaks its own language. So there in PowerPoint presentations, I find the PowerPoint presentations which are followed as such with, something written along with it. And essentially the reader is speaking in relation to what he has already written. To a certain extent, captures the attention of the masses. But beyond a point, they get bored. So definitely visuals are effective. And in situations when we argue, for instance, there are instances where, of course, when we are dealing with the spot of the crime, for instance, say, visuals of the spot of the crime make all the difference. It is one thing to argue a matter on the basis of a site plan. Another thing to show a site plan in work by way of a visual. When the court looks at that, it draws its own conclusions in a very different fashion. At times, it so happens that in today's times, you have all these cameras placed at all places. Invariably, they take rushes of incidents happening. And when that happens, I had the occasion of doing a few matters where a fight broke out on the street. The entire fight got filmed by one of these cameras. And the complainant side, the best thing that the complainant side could do, they just played that part. And there was very little to argue thereafter. I was representing, of course, the accused. I got shut out by the court. Because all this was available there. So that is the kind of impact a visual has. But it depends on how effectively you can use that visual. Having said that, then of course, some things which we get to know out of experience. We have the habit of, re-arguing what we have already argued. Something which courts normally do not take to very kindly. That I can tell you by experience. And that happens generally in a rejoinder. Whenever we rejoin what has been argued, we have the habit of trying to open up the entire thing again. And when we do that, one, we confuse the judge. We do not address what has been argued by the other side. Of course, we may end up impressing our client. कि बड़ी बहस किया जी, पर क्या हुआ, as they say in local language of the criminal litigants, they say बहस पानी में उतर गई. After a while, the decision is against you. Though you had a good case, the reason was that you did not address what was being addressed from the other side. If it is pointed and it is short and it addresses what the other side said, probably you will be much more effective. And of course, we should know when to sit down and stop arguing. That, in fact, I think is the best way to persuade someone to a viewpoint. So I think it is time that I also sit down. I have argued enough. And thank you very much for having tolerated me after a long, long day. Thank you so much.
Thank you, sir, for such an enriching session.
Was it?
Yes, of course it was. I would say this on behalf of everyone. So now the floor is open. If any one of you have any question to pose to sir, you may kindly raise your hand.
Yes, Pushpa.
So, how important are written arguments in the present context, especially post-COVID? I think most of the courts want written arguments.
I somehow am not a very votary for written arguments. A written argument at the most can be an 8-day memoir, somewhat aiding what you have said. But the impact which is there when you stand up in court and argue your point, that leaves a lasting impact. The techniques which I just spoke of, none of those techniques will be of any use in a written argument. It becomes completely redundant. You see, because the engagement that is there with the judge doesn't happen. They tell you, you give 3 pages, you give 3 pages, ultimately nobody engages with anyone. So that engagement is what is most important. As they said in the rhetoric, how do you get to know the mind of the judge? Until and unless you engage him into it. You draw him out. You will always find that judges who do not speak are the most difficult ones. So our skill as a lawyer should be to draw the judge out. Confront him. Create a situation where he gets drawn out. And then you will get to know what his psychology is and how to deal with him. This is what I feel. Written arguments probably may help them in writing a judgment. But it doesn't help us in any way. So we should insist that we will argue and they will give an 8-day memoir later. If he scuttles the argument itself, we have lost half the battle. This is my perception and my belief. Yes? You'll have to give her the mic.
Hello. Sir, this might not relate to the skills of arguing as such, but this is a question which is more about court craft as such. I would just like to ask you one thing. For example, there's a slightly difficult case in which you are very sure that I might lose. In that case, there is some information or a piece of document or something which goes against you and is available with you at that time, but not with the other party. So at that time, or there's a fact which the judge puts to you and you know the answer of, but the answer could go against you. So at that time, will you, what is the right thing to do? To assist the court as the officer of the court, or at that time just think that if I answer
It's a very good
this,
question. We normally get faced with something like this.
Yes, sir. So
but where you feel that the court is questioning you, it is better to be upfront. You acknowledge your weakness. That this is where my case is somewhat weak. The court will appreciate the fact that he is dealing with a counsel who is forthright. He is dealing with a counsel, and that is dealing with that part of rhetoric that I spoke to you, ethos. It is the perception which is being created in the mind of the judge. See how it is working, the rhetoric. The moment you come up with this upfront straight away, that sir, I am beginning my argument. This is my weak point here. This is my Achilles foot. Now the arrow that you shoot, because the Achilles was a great warrior during Trojan times. All of you know. The only way Achilles could be defeated was when the arrow would go towards his foot. So if you expose your Achilles foot and tell the judge that look, this is my Achilles foot, and here on, this is the manner in which I intend dealing with this, he will be a better listener to what you say. He will have a perception that here is a counsel who is straight, here is a counsel who will not mislead me, here is a counsel whom I can trust. It is that trust which will win you 50% of your case. And that is how rhetoric comes into employment, as I told you.
Thank you, sir.
Very good question. Man, we face this every day. It is better not to hide. Because the judge, in any case, when he reads the file on his own, he will get down to it. And then he will remember that I had put this to the concerned lawyer, and this is what she did. She avoided it and moved on elsewhere. So don't move on elsewhere. Take the bull by its horns, confront him. Think about your answer, because you will know what your Achilles foot is when you do your case. You know the facts, you have gone through the facts, you know, हाँ यहाँ पे गड़बड़ है, यहाँ पे प्रॉब्लम आएगी. अब उसको कैसे कम्बैट करना है वो तुम उसको आउटथिंक करो and confront it. Don't avoid it.
So thank you so much for a very insightful session here, sir. Sir Kuljit this side.
Who's this?
Sir, this Kuljit this side. Thank you for
Okay.
your insightful session. My question is, there are instances wherein judge says ki you argued in 5 minutes or 10 minutes and concluded very limited period. So even that happened with me some often, and it is practice established by few judges. I won't name it. So how would a person deal with that situation? Because you have to complete your argument, it would take 15, 20, 30 odd minutes to deliver whatever you have in your mind. But the question comes from the other side, you have to deliver in 5 minutes or 10 minutes. So how would a person deal with that situation?
See, time constraints are something which has to be dealt with tact. In a situation where you know that here is a judge who is going to bind me by time, and this is happening more frequently because what judges are doing, they are following the American system. In the American system, whichever case it is, there is a time slot which is given to conclude your presentation, conclude your argument, or maybe address the jury in case of criminal trials. Everything is bound by time. So slowly these people are also veering towards it because they have this belief that we are clogged with cases and the only way of disposing it is to bind lawyers in relation to timings. So we go with a particular construct that here is a judge we know who is going to bind me with time. You start upfront with him, saying, sir, I know, for instance, is one way of doing it. Tell him, sir, I know for definitely that you are a person who is a stickler for time and you have allotted me 5 minutes. Right? Now, I'll just give an example, for instance. There is a question of pleadings also. At times, judges get irritated that why is this pleading going into 20 pages? He says that I want an argument in, there is a file which is this thick and he'll say that give me a 4-pager.
Yes.
So one way of looking at it, for instance, we look at it from the civil side, that example I can give, that there is a case where there are say 15 defendants and you are the plaintiff and he's told you to paraphrase it in probably 4 pages or 2 pages. So you tell him upfront, for instance, you could take this as a ploy. You have to find that ploy. In this particular case, the ploy is that, sir, this is a case where there are 15 defendants. So 5 minutes if you are giving me, please consider the number of defendants and accordingly adjust the timing a little bit. You will fall for the trap. So you have to find that ploy in each of your case. For instance, once what happened was, in R.K. Sharma, that Shivani Bhatnagar's murder trial, post the trial, it came up on an appeal out here. We got an acquittal there. But for R.K. Sharma, the others had got acquitted. So I was representing one of them. So it came up before Justice Badr Durai's. And he had got sick by that point of time, because the matter was going on for many days. The matter was huge, a lot of evidence to be marshalled. So when my turn came, by then he had been exhausted. So he looked at me and said, now Ariyaran, how much time will I have to listen to you? So it just struck at that point of time, that let me lighten it with some humor. So I said, by the clock, sir, 2 minutes. He said, by the clock, 2 minutes. Alright, let's see how you conclude this argument. In 2 minutes. So I looked at him and I said, my lord, there is no evidence against me, I am innocent. And that's it. So he looked at me, laughed. He said, alright, come tomorrow, argue. So you have to, essentially, depending on the kind of situation that you are, you have to think that out, my friend.
But sir, I have one practical problem.
Thank you, sir.
By and large, they are generally generous, ऐसा नहीं है, at the moment, but I don't know how long it will last.
Practical
Yes.
problem is if the judge wants to buy in with the time and you will respect that. 5 minutes. And you say, okay, my lord, I'll try. Fine. But you don't get those 5 minutes because the moment you open your mouth, there is a query from the judge. There is a disruption from the other side.
Yes.
So 5 minutes.
So you could respond by saying that those 5 minutes were uninterrupted, my lord.
No, that's all right. But I was only wondering because at times if you even politely tell them that yes, my lord, just give me 5 minutes uninterrupted, it's not taken into
Taste.
taste and the reactions are not very friendly. So therefore,
You see, all this, Anu, is happening because of the fact that they are overburdened with work, number one. Number two, what happens is that we also don't know when to let go. If you give license to a lawyer, he will never end. He'll go on. Till probably the time he thinks that the judge is going to say, all right, now I am convinced with you, and I give a decree in your favor, or I acquit your client. That's not going to happen. So that is why I said one of the attributes of persuasion is when to stop. We also, there is contributory negligence on our part. We love our voices. Don't we? So, given a chance, you'll go on. You'll keep dilating the same point in some way or the other. So, we also need to, so how we can address this is one way, we structure our argument. We know for certain that this judge is not going to give us more than 10 minutes. He is not going to give us more than 5 minutes. We structure our argument that within this, it is this that I will address. So broadly, you will put pointers. That there are 8 pointers, sir, in relation to my argument. Right? In those 8 pointers, you make up your mind that what is the best evidence that you will marshal. So, coming back to rhetoric, you will go into that aspect as to what is your best argument that you will place first. And you will end that submission of yours also with that best argument reinforcing what you said. The middle you will occupy in relation to the evidence part which you wish the judge to look into, which he can read himself. Mark those portions and tell him that these are the portions, sir, this is how you have to deal with it. These are the confrontations in terms of criminal law which you need to look at it. These are material. These are omissions which are material. These are contradictions which are material. So structure that and then present it. You will manage in that time. What happens is that we don't structure that because we also don't have time to prepare. और हम भी बस नहीं करते हैं, हम भी दिल्ली लूटने के चक्कर में रहते हैं। हमारे बस में अगर 10 सीट है, हम उसमें 100 भर देते हैं। मैं भी करता हूँ। फिर मैं पढ़ूंगा। अब आज मैंने 100 भर दिए थे सवारी, इसीलिए मैं यहाँ लेट हुआ। और यहाँ मैं अनप्रिपेयर्ड आया। तो मैंने कहा जो मेरे मन में आता है वो बोलता हूँ। My friends will tolerate me. So all this, has got some element of organization, which is also very important in a lawyer's case. I am one of the most disorganized persons that you can think of, so don't emulate me. But I remember Pandit Ramkishan Nasim, he is no more. He was one of the most meticulous lawyers I had seen. The entire file, the criminal file, used to be flagged, indexed. You could just flip through and reach where you wanted. It used to save his time. I learned from one of the greatest seniors that you could think of. Mr. Grover was my senior, Vrinda's father. But he was the most disorganized person that I had ever seen. He had no patience. So what would happen if it would even take 5 seconds, to give him something? He would pull the entire file, take out the paper and push it across to the judge. So our files were all very badly maintained. So I have probably inherited that from him. I do regret that. Now flags, people flag their files very well. I remember Sandeep Sethi, for instance. You look at his file. Any one of you who has had the occasion to have worked with him, everything is in text. Everything is flagged. So he goes, rat-a-tat-tat-tat. The moment anything starts, he knows where to go. He has charted his path. Unlike Hariharan. Hariharan thinks that he can produce everything from his mind. So there is nothing flagged, no document is in place, and my juniors have a hard time. I'll argue and I expect them to go pull the document. I am trying to improve upon that, पर नहीं हो रहा है. क्या करूं? So every one of us has their weaknesses, every one of us has their own strengths. So that depends on that. But this can be addressed, what you're talking, those 5 minutes or 10 minutes that you have, that can be addressed. Just think over it, that's it. Organize yourself. और बताओ.
Any other question?
Only 5 minutes more?
So I think you have really justified the topic of the session today through your insights and words. So
I was just wondering, what do I speak on this topic? Skill of arguing. What skill can one have?
but sir, you truly did justice to the session today and the topic.
Tell what? Ignore the media. Ignore the media. That's the only answer. Don't interact with the media. I did a few of them in my life. It started with Dhclsc, where every day the trial used to happen in a place like Vigyanba. There is something which, I can never forget, because that is an opportunity which I got, which is very rare to do a trial there. So the press used to be outside the moment you come, and I was defending a client who was the poorest amongst the lot, but who appeared on every tape. So I had to do the bulk of the cross-examination there. So, in these kind of matters, what happens is that you don't augur the interest of your client when you interact with media. So don't do that. If you are into the trial, don't interact with them. I did 2G, for instance. You very rarely saw me on television. So this is the school which I come from, where we think in the interests of our client than in relation to auguring our PR. It will never help the client. So media, don't bother, because they give skewed opinions. They look for sensation. I myself came from the press. I was a journalist in my earlier life. So I know what we search for. So we like sensation. We like something, which will attract the attention of people in a different way. Every man likes crime, I don't know why. Kuch hai. Though it may be a no-go, but it is fascinating. I have seen it from my own relatives, The first thing they'll ask is, uska kya ho raha hai? Tandoori wale ka. So that, it is that element which the media addresses. And that is something which you do not want. And you believe in the innocence of your client. The kind of questions that they will put to you will expose you in a very different way. Why do you want to do that? Keep away from them. थोड़ा सा PR बन जाता है, पर उससे कुछ नहीं होता है. Without approaching the press, if you do your job diligently, still you will get a lot of work. They will come to you because of the fact that you deliver. They will come to you because of the fact that even if you don't deliver, that you have been diligent. And you were not at fault. I always tell my clients, whosoever comes to me, that look, getting relief for you, two things have to combine. एक तेरा मुकद्दर और दूसरी मेरी मेहनत. अगर इन दोनों में से एक गया, तो you won't get relief. So that's the way it is. So media, ठीक है. Once you win the case, you talk to them. But not when the case is on. Never do that. और बताओ. What to tell lawyers, yeah? They have their own ways and means, huh? Some share, of course, is on my back all the time. So we call it quits from the session, not from courts.
Thank you, sir. Let's give
Thank
a
you so
huge
much.
round of applause for sir once again.
Thank you so much.
Thank you, sir. Your association with Delhi High Court Legal Service Committee is highly valued and appreciated. Thank you, sir.
I value it as well, because I think that is something which all of us should cherish. Each one of you being here shows that you value something more than making money. And that is what is important. Making money is always there, you need only that much. So this is a cause which is very dear to me, and a cause which I try and do whatever I can from my end. Around 40 to 50% of my matters are all pro bono. बाकी रॉबिन हुड का काम करता हूँ.
Thank you, sir. Thank you. Thank you, everyone. I would request everyone to kindly join us for high tea in the lounge area. Thank you. Thank you, everyone.
And I decided to go